Well, hello everyone, and welcome back to Uncivil Law, where as always we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Virginia, Texas, and before the United States Supreme Court, and I hope today is the day I earn that subscription. For today's stream, I wanted to respond to a recent comment that I saw on a video I did on an attorney's react, because I do like to read the comments on my own videos, and I do like to read the comments on videos I produce to see what people think. And sometimes there are some good questions, or people have a point of law that they think that there's something that I missed. And so when I see something like that, I'm like, oh, okay, there's an interesting idea. Let's go read what this person has cited and see what it stands for. Okay, so in this video of Attorneys React, I had said that an officer can use a visual estimate to pull someone over. The idea is I see someone driving down the road. I think they're speeding because I can see it visually, and that is enough basis. And someone said, well, that isn't true. The Fourth Circuit said you can't do that. And I'm like, that seems odd. So let's go figure out if that's true. So that's what we're going to do today. So we're going to read this decision from the Fourth Circuit, which deals with this issue. The police's ability to use a visual estimate to pull someone over. So is the Fourth Circuit saying you can never do this? Are they saying you can only do it under certain circumstances? Is it fact dependent? Is it legal dependent? So what exactly is the rule? So we're going to read this case and try to get started with this. This is from the Fourth Circuit Court of Appeals, 2012, United States of America versus Sowards. And we're going to read this issue, which deals with exactly this issue. The police use a visual estimate of speed as a basis for a traffic stop. All right. So on appeal, Mr. Sowards argues the district court erred in denying a motion to suppress because the police lacked probable cause to initiate a traffic stop based exclusively on an officer's visual estimate, uncorroborated by radar or pacing, and unsupported by any other indicia of reliability, that Sowards' vehicle was traveling 75 miles per hour into 70. We agree and therefore reverse. All right, so we get the sort of the hit right away, right? We got this guy, the officer says you're going 75 into 70. No radar gun, no pacing, no other sort of indicia of reliability, right? Just sort of the naked visual element alone. And we say that this is a problem. Okay, so what is the nature of the problem? In order to understand that, let's read. Defendant James Elliott stopped Sowards for speeding in North Carolina after visually estimating Sowards' vehicle was traveling 75 into 70. Although the deputy's car was equipped with radar, he had intentionally positioned his car at an angle that rendered an accurate radar rating impossible. I'm not sure why he did that, but apparently he did. During the traffic stop, the deputy had a canine trained in drug detection. So he has the dog on him, which is important because you can't call the dog anymore after the U.S. Supreme Court clarified that, right? If you happen to have one on you, then fine, but you can't call the dog in to extend the traffic stop. But if it's there, it's there. So this guy apparently has a canine on him at the time. So the deputy had the canine stiff outside the vehicle. That seems to be within accord with the Supreme Court, right? That seems to be fine because the canine was already there. When Ringo signaled the presence of possible controlled substance, the deputy, along with other officers, searched the vehicle and discovered 10 kilograms of cocaine. Subsequently, a grand jury charged him with possession of at least 5 grams of cocaine with intent to distribute in violation of law. So we got a standard traffic stop. We got a drug dog. Apparently was already on the scene. The drug dog is doing a search of the car. This seems to be in accord with the U.S. Supreme Court, and we find the cocaine. So, all right. Before trial, we moved to suppress on the evidence that the basis, the deputy, lacked probable cause to initiate the traffic stop in violation of the Fourth Amendment. So the problem was the basis for pulling me over in the first place, for the poison tree. At the suppression hearing, the deputy testified he was certified in the use of radar equipment in North Carolina. As a condition of obtaining the certification, he was required to visually estimate the speed of 12 separate vehicles and have his visual speed estimates verified with radar. So he has some experience in looking at cars and seeing how fast they go, and he has to match what the radar says in some version of that. Okay. To pass the test, the deputy's visual speed estimates could not vary from the radar by a greater of a total of 42 miles an hour for all 12 vehicles combined. The deputy, however, testified that for any one vehicle, his visual estimate could have been off by as much as 12 miles an hour, so long as he did not exceed 42 for all 12. So he has this range, right? He has to be off by no more than an average of about 3 miles an hour, per a little bit more, 3.5. But he could be off by as much as 12 as long as he was more accurate on all of them. So when we're trying to determine whether someone's within 5 miles an hour or not visually, right? What's your experience for being able to say that, right? And so this guy apparently says, well, I could be off by as much as 12 miles an hour, which is a bit of a problem when we're trying to say someone is over by 5. Over the objection of the defense counsel, the deputy testified they visually estimated the speed limit. The estimated was traveling 75. The deputy further testified that the posted speed limit was 70, and therefore he was exceeding legal speed by 5 miles an hour. The deputy also stated he did not attempt to verify or otherwise corroborate his visual speed estimate with a radar. He didn't attempt to pace the vehicle with his patrol car, and he had not been trained on, and therefore did not use a different system that was available, which uses a stopwatch to estimate the time it takes to use over a distance. So just using his eyeballs. So that's the only tool we have. When asked what technique he used, if any, to estimate the speed of the vehicle, this was the testimony. Question: and did you learn certain techniques in visually estimating the speed? The deputy: there's not really a technique. I've been measuring speeds all my life. Question: and the radar serves what function in relation to your visual observation of the speed of the vehicle? Answer: it's just a second opinion that already corroborates what you already know. Question: you testified earlier that there's no technique to estimating speed. You use no technique, is that correct? The deputy: you don't need a technique. It's all based on your training experience. As long as you have a tracking history and you have experience in observing speeds. Question: so you can basically look at a vehicle and guess? Answer: there's no guessing about it. It's an estimate based on tracking history and training experience. We have a different view of the word guessing, I suppose, but fine. Question: based on tracking history? Answer: that's correct. Question, which would be? Answer: being able to sufficiently see the vehicle, that vehicle coming towards me, the vehicle passing me, being able to estimate the vehicle speed. Question: how long did you watch the vehicle? Answer: at this point in time, the vehicle was approximately 100 yards out in front of me. Question: football field. Answer: approximately. Question: approximately, so you can estimate the distance. Okay. So far so good, right? So far so good. These lines of answers make sense because these are the kinds of answers that would make sense for a lay person to give an opinion, right? So lay people can give opinions as to things lay people would have knowledge of, things that are within their everyday knowledge and experience. So if you ask a lay person a question like, how fast is a vehicle going? They might very well be able to answer the question because a lay person has experience in being able to see the things, right? So yeah, you might be able to tell from based on your experience how fast a car is going. So this is sort of his answer, right? He's like, there's no particular technique in it. It's just based off my experience in seeing cars. There could be technique, right? There could be special training, but there isn't, right? He's just a guy for the purposes of this answer. It's the same answer you or I would give, right? How fast are you able to determine a car is going? Well, I've been driving cars all my life. I've been seeing cars being driven all my life. It's just based on my understanding of how fast cars go. So the same kind of answer that you and I could give. So, okay, maybe. So this is what the officer says. It makes some sense. All right. So far, so good. Subsequently, however, the deputy testified he didn't measure the distance that he had tracked. And his testimony of 100 yards at the tracking history was an approximation rather than a certainty. I mean, okay, fine. Furthermore, on cross-examination and questioned directly about the district court about his knowledge of distances, the deputy gave several inconsistent and incorrect answers regarding measurements. This is where things get more exciting, people. Right? So this is where things get more exciting. It's like it's 100 yards. Okay, there or thereabouts. It's like, oh, okay. All right, now we're going to move from the reliable into the unreliable. Question: how many feet are in 100 yards? Answer: there are 12 feet in a yard. Question: so 300 feet? Answer: correct. His knowledge of the number of feet in yards and his math skills suck. At 12 feet per yard, 100 yards would be 1,200 feet. So first of all, we're not sure how many feet are in a yard. And also, our math skills suck, I guess. All right. So this is promising. The court: how many feet are in a yard? Deputy: how many feet? There's 12 feet in a yard. Great. The court: well, do you know what a yardstick is? Yes, sir. How many inches in a yardstick? Well, in a yardstick, there's 12 inches. Well, it depends on the yardstick that you have. Wow. It depends on the yardstick that you have. How many inches in a yardstick? It depends on what kind of yardstick you have. Wow. I love this answer. I love this answer. Unless we're going to do some really hardcore geek shit with like the difference between statutory miles and like nautical miles. And like I think there are technically like 3 or 4 different kinds of miles, or 3 or 4 different, I think there are maybe 3 or 4 different answers to this question, but I don't think that's the nature of his confusion. It's like, I don't think the nature of his confusion is, oh, I thought we were talking about statutory miles, or I thought we were talking about survey miles, or I thought we were talking about nautical miles. I don't think that's the nature of his confusion. So, yeah. He thinks that there's, yeah. Use your hands to indicate a yardstick. A yardstick is about that long. All right, and how many inches in it? 4 feet in a yard. We're not doing great over here with our knowledge of feet, inches, yards, or other measurements. It's not going great over here. It's not going super well. Thereafter, the deputy testified his visual estimate of the speed of the vehicle was not dependent on his ability to estimate distance that it traveled. Which, I guess, right? You may not necessarily need to know how far it went to know how fast it's going, depending on your ability to see fast objects. If you have a window, if you could imagine, like, I don't know, you're sitting in a cafe somewhere and there's a window and like there's a road right outside the window and you see a car just fly by, right? You might not be able to see, you might see it only travel the length of the window, but you might still be able to estimate how fast it's going despite the fact you are not seeing it for any particular distance. So is your ability to know how long it went indicative of distance or indicative of speed? Not necessarily, but we're getting some ideas that maybe this guy's observation skills are less than fully reliable. All right. Question. So how can you estimate speed without knowing the distance? Answer. Based on my visual observation, I know that it takes a quicker time for vehicles to come at me at 75 miles an hour per 75 miles an hour in that area. Well, I mean, not to put too fine a point on it, but presumably it's quicker for vehicles to come at you at 75 miles an hour rather than 75 miles an hour in any area, because unless we're in the Bermuda Triangle or something, right? I don't think there's anything magical about the area that makes it quicker for a vehicle to come to you when it's going 75 versus 70. I'm not sure in the area is necessarily relevant to this equation. Pressing on. The reason why I know that is I've been working in the area for approximately 4.5 years. I've conducted radar enforcement. I also conducted speed estimates of vehicles that I see going to work on the area on a daily basis. Well, how can you be certain the vehicle is going 75 miles an hour? My training and experience, which of course is every cop's favorite answer ever. Could you explain the specifics of your visual estimate training as far as you arrive at speed? Because I know a vehicle traveling 75 miles an hour, it gets faster to me than one traveling 70 miles per hour by my visual observation. I mean, yes, I suppose that is how speed works. So, okay. The district court denied the motion to suppress, rejecting the argument and finding there was probable cause to initiate the traffic stop, saying, quote, the officer had probable cause to believe a traffic violation occurred based on speed. He's trained to estimate speeds. His difficulty with measurements is immaterial to estimate of speed, as it did not depend on time or distance. And the certification he received, I believe, 3 different times, dependent on accuracy in estimating speeds. So it particularized an objective basis for suspecting that traffic violation had occurred. Okay, I mean, yeah. His inability to know how many inches are in a feet or a mile or yard or anything else maybe doesn't influence his ability to know speed, but it doesn't suggest that he's particularly smart. So subsequently, the defendant entered a conditional guilty plea, reserving the right to appeal. So this is something that you can do sometimes. Normally the government won't give it to you, and usually they only give it to you if they're like really, really sure they're going to win, right? Because they're like, okay, sure, you can plead. Because normally when you plead guilty, you waive the right to appeal, right? That's normally part of the deal. You waive your right to appeal by pleading guilty. But, every once in a while, you'll be like, I'd like to plead guilty, but reserve my right to appeal. And the government will be like, sure, you reserve your right to appeal. And then this kind of shit happens. So the only government only gives it to you when they're sure they're going to win, and then every once in a while they lose, which is kind of hilarious. So notwithstanding the fact he pled guilty, he had the right to appeal. Fine. At sentencing, the district court sentenced him to 70 months imprisonment, which was the low end of the guidelines for the drugs, and we timely filed appeal. So I'd like, not to spend the next, 5 years and change, 6 years of my life in prison. So, all right. Let's see whether or not the judge made the right decision at the suppression hearing. The issue on appeal is whether the deputy's traffic stop of the vehicle was supported by probable cause, and accordingly, whether the district court properly denied the motion to suppress on the basis of the traffic stop. We review the legal determinations de novo and factual determinations for clear error. Under clear error, a factual finding by a district court may be reversed only if, although there's evidence to support it, the reviewing court on the entire evidence is left with a definite firm conviction the mistake has been made. So basically, manifest weight of the evidence is kind of what you're looking for, right? So we're only going to reverse a factual finding if, what you said is crap. Otherwise, the district court gets the ability to determine facts. So overturning a district court on the facts is going to be hard. Not impossible, not unheard of, but, appeals are for losers, as they say, so I wouldn't bank on it. The evidence is construed in light most favorable to the government, right? Because innocence till proven guilty is over now, which is the other huge factor about that, right? So since innocent until proven guilty is over, because, guilty, then the government is going to win this unless they can't. So you have to prove the government can't win it. So, yeah, you have to prove it because the burn's on you now because you've been convicted, remember? You have the burn. You prove the government can't win when viewed in the light most favorable to them. It's tough. The Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. When a police officer stops an automobile and detains the occupants briefly, the stops amounts to a seizure within the meaning of the Fourth Amendment. The underlying command of the Fourth Amendment is that search and seizures be reasonable. An automobile stop is subject to constitutional imperative that it not be unreasonable. As a general matter, the decision to stop an automobile is reasonable where the police have probable cause to believe a traffic violation has occurred. Probable cause exists if, given the totality of circumstances, the officer has reasonably trustworthy information sufficient to warrant a prudent person into believing that the person has committed or was committing an offense, which, is kind of what you'd expect. Accordingly, our inquiry here is whether, given the totality of the circumstances, the deputy had a reasonably trustworthy information sufficient to support a prudent person in the belief of speeding. So this sounds like this is turning into it sounds like the court's going to issue a decision as to this particular set of facts, right? It sounds like the court is not going to issue a decision that's globally, right? So it's like, okay, based on this set of facts, could this officer do it, right? As opposed to officers in general. So this is one of the things that I sort of counsel people against because I think this is the direction the court is going, right? They'll see a decision where there's like, oh, the Fourth Circuit says you can't use visual estimates. And I'm like, yeah, that's probably not what they said. They probably didn't say they probably didn't say an officer can't use visual estimates, but although maybe they can. The question isn't whether an officer can. The question is whether this officer can. And there is a distinction, right? So could some other officer use a pure visual estimate? Maybe. The question at the moment, at least, is this guy, because this guy is apparently an idiot. So, all right. So let's see if we're answering this in a more local way and a more global way. The district court found that the officer had probable cause to believe a traffic violation had occurred because the officer was trained to estimate speeds and because certification he received depended on the accuracy in estimating speeds. The district court also found the officer's difficulty with measurements immaterial to estimate speed as it doesn't depend on time or distance. Okay. Based on these findings, the district court concluded the officer has a particularized and objective basis for supporting a traffic violation has occurred. We hold on the record before us that several of the district court's material factual findings are clear error. So we're going to overrule the district court on the facts, which is pretty hard. It's pretty hard to say the district court fucked up the facts, but we're going to say they fucked up the facts. All right. First, it was clear error for the district court to find the deputy was trained to estimate speeds. Contrary to the finding, the record indicates the deputy was trained to use a radar unit. Rather than being trained to estimate speeds, he was given the opportunity to guess the speed of 12 vehicles, and doing so demonstrated the proficiency of guessing within a total margin of 42 miles an hour for all 12 of the vehicles in the test. There was no testimony or evidence the deputy received any specialized training in estimates of speeds. In fact, the deputy's testimony confirms that he uses absolutely no technique or method to visually guess the speeds. Given the testimony and absolute evidence of contrary evidence, it was clear error to find the deputy was trained to estimate speeds. Right? So his ability to guess speeds is one thing, but for the court to say he was trained to estimate speeds, no. He was asked to guess and he guessed right, but he wasn't trained. They didn't have any sort of program where they like showed him cars and they showed him like how to estimate, or there was no training curriculum. There's just like, what is your best guess? Guess the weight, that will show up on the scale. Isn't quite the same thing as training. So that was a bit of an error. Okay. Second, it was clear error for the district court to find the deputy's difficulty with measurements is immaterial to estimate speed, as it doesn't depend on time and distance. The finding rings in the absurd because one cannot discern the speed of a vehicle measured in miles per hour without discerning both the increment of distance and increment of time. See, I'm not sure if I agree with that, to be honest, because again, it's this like whole idea. It's like if just imagine that we're sitting again, like imagine you're sitting in a cafe and you're sitting by a window and a vehicle goes by the window. It's like, can you estimate how fast it's going without knowing like the distance, just based on the visual observation? It's like, yeah, you probably have some clue. So I'm not sure if I agree with that, but that's what the court said. Indeed, the very definition of speed derives from a mathematical formula of distance divided by time. This court may properly take judicial notice, which, fair enough, because that much is not disputable. That is what speed is. So, I'll give you that. Furthermore, the materiality of the deputy's difficulty with measurements was established by the deputy's own testimony. During the suppression hearing, the deputy exhibited a notable absence of fluency and knowledge of distance memberships. This is where things get more problematic. Deputy testified that there's 12 feet in a yard. 300 yards would be 100 yards. And on a yardstick, there's 12 inches. The deputy also testified the number of inches on the yardstick depends on the yardstick, and the math could change depending on the person who's behind it. These are not encouraging statements. In light of the testimony, it's material and indeed troubling that the deputy asserted his visual estimates of speed are dependent on his observation of tracking history of the vehicle, testifying a technique is not required to estimate speed as long as you have a tracking history, and his method of estimating speed is not a guess because it's an estimate based on tracking history. Given the deputy further testified that he had 100 yards of tracking history to estimate the speed, it was clearly erroneous. Well, if his tracking estimate is based off the distance, which he testifies to, and he doesn't know the distance, now you have a problem. Right? So if it's like, oh, I can do it because it's fine as long as you have a tracking history. So like his claim isn't, I could spot the car going past the window, right? I could see the car for as long as it passed by the window, and I would know how fast it was going, right? That wasn't his claim. His claim is I can do it as long as I see it traveling for a length of road. I can tell I need at least 100 yards in order to tell. And see, the problem is you don't know how long 100 yards is. So it's like, if your ability to detect this is based on your ability to observe the car over a distance, and you're not sure how far distances are, then, now you have a different claim. So this is like boiling down a lot to his claim. It's like, it is, I'm specifically able to tell how fast cars are going because of tracking. I had 100 yards of tracking history, but I don't know how far 100 yards is. So now distance is kind of important in this equation because you've made it important. Yeah. Notwithstanding the two clearly erroneous factual findings, the government contends the visual speed estimate standing alone provides probable cause to initiate the traffic stop. However, the Fourth Amendment does not allow, and the case law does not support, blanket approval for the proposition an officer's visual speed estimate in and of itself will always suffice as a basis for probable cause to initiate a traffic stop. So, this is where I sort of tell people to be careful about how they read decisions. Because the person who was aware of this decision was like, well, the Fourth Circuit says you can never use visual speed. And I'm like, no, that's not what they're saying. They're just simply saying you can't always use it. Not that you can never use it. Those are two very different propositions, right? So it is not always sufficient. Indeed, for the purposes of the Fourth Amendment, the question remains one of reasonableness. Critically, and as further explained below, the reasonableness of an officer's visual speed estimate depends, in the first instance, on whether the physical speed is estimated to be in significant excess or in slight excess of the legal speed limit. If slight, then indicia, evidence, and reliability are necessary to support the reasonableness. So it's like, okay, if the car is, traveling down the road, 40 miles an hour over the limit, then the Fourth Circuit's like, cool, right? The Fourth Circuit's all like, cool. If this car is traveling 40 miles and over in a limit, we think that you can figure that out. But if it's close, like this is, 5 miles an hour over, right? The difference between 75 and 70 is kind of tight. Can you tell the difference between 75 and 70 at a glance? It's like, well, maybe you can, but can you establish that? Because we think, the everyman can do it at speeds, but, you're trying to slice this pretty thin. So can you show us why you're able to do this? And the answer is no. So again, it's not that you can't use visual speed estimate ever, it's that you can't rely on it as your sole factor when you're trying to slice it this thin. In United States versus Ludwig, our sister circuit framed the analysis similarly in holding an officer's visual estimate can supply a probable cause to support a traffic stop for speeding in appropriate circumstances. Although it did not elaborate on the circumstances that may make a visual speed estimate to supply probable cause, we find that at a minimum, there must be sufficient indicia of reliability for the court to credit as reasonable the estimate. So, we just want it to be, reliable. We want to, not be completely made up shit. And maybe there's an officer out there who can do this and can explain how they can do it. Maybe there's an officer out there who can tell the difference between 70 and 75. And he can explain it and we'll all be happy. So, but this officer is not exactly instilling us with a lot of confidence because it's this officer. So, yeah. Rob asked in chat, if it's not irrefutable and documented, then how was it ever considered evidence? That doesn't, perhaps you misunderstand what evidence is. Evidence is often disputed. Evidence, it doesn't have to be irrefutable to be evidence. If you and I are eyewitnesses to a traffic accident and I testify the light is green and you testify the light is red, we're both providing evidence. So the fact that we disagree doesn't make either of our testimony not evidence. It doesn't have to be irrefutable to be evidence. Evidence is often refutable or rebuttable or disputable. So yeah, I'm not sure why you. Yeah, and it's documented. He wrote it down. So I heard the witness say this. You hear the witness say this. Yeah, evidence can be disputed. So I'm not sure what you think. What the nature of your question was there. Thus, when an officer estimates that a vehicle is traveling in significant excess of legal speed, the speed differential, that is the percentage difference between the estimated speed and legal speed, may itself provide sufficient indicia of reliability. So if you're traveling really, really fast, you can probably tell the difference. You can probably tell the difference between a car going, 60 and a car going 15. That's probably something we feel comfortable with. Yeah. However, when an officer estimates the vehicle is traveling in only slight excess of the legal speed, and particularly where an alleged violation of is a speed differential difficult for a naked eye to discern, because while we think sort of the everyman can tell the difference between 60 and 15, we're a little bit less confidence between like 75 and 70. An officer's visual speed estimate requires indicia of reliability. And then they cite some case law. They cite one from New York. Finding a stop was unsupportable by probable cause and explaining in the absence of an estimate the vehicle is traveling in significant excess of the legal speed limit. Courts will credit an officer's testimony regarding firsthand observation of a speeding vehicle if additional specific details of his or her account confirm the officer's observation and belief were reasonable. So can you give us more? Citing an opinion from Missouri, holding an officer's uncorroborated opinion of an evidence defendant's 45 and a 35 was insufficient to allow a trier of fact to find that the defendant was speeding. Citing a case from somewhere, New York State, I guess, absent mechanical corroboration, testimony that vehicle was proceeding at 35 to 40 in a 30 might, for obvious reasons, be insufficient to sustain conviction, since it must be assumed that only a mechanical device could make such a slight alteration with accuracy. Citing a decision from Missouri, when an officer's estimate of speed is 60, a fact finder cannot conclude with any degree of certainty the defendant was exceeding 55 because the accuracy of human estimate of speed cannot easily, readily, and accurately discriminate between such small birds' speed. Citing a decision from Maryland, an estimate is necessarily approximate and not exact without mechanical aid. It is manifestly impossible for anyone to estimate precisely the speed of a moving object. And the fact is assumed by everyone possessing ordinary common sense. All right, fair enough. The reasonableness of an officer's visual estimate that a vehicle is traveling in slight excess of the legal speed limit may be supported by radar, pacing, or other indicia that estimate in totality of circumstances the reasonableness of the estimate. So, what other things you might have other than radar or pacing might be other traffic, right? So, if you're sitting by the side of a road and the speed limit is, say, I don't know, 25 miles an hour, right? You're sitting by the side of the road and you're watching traffic go by on this 25-mile-an-hour road. You're going to get a sense of how fast the cars are going, right? And then you see a car that's traveling faster than that, or maybe even better, it's traveling faster in the context of other cars, right? So you sort of know what the normal car looks like, and now this car is going faster than that. Maybe that's enough. Maybe it is, right? You can make the argument. So there might be other indicia, or, you had a stopwatch, or you saw them, pass by, two markers or something. So it's like, what are you basing it off of? So we need to have something a little bit more than, my spidey sense. Let's see, where was I? Okay, finding probable cause where estimate was verified by radar. I mean, yeah. Finding probable cause, reasonable suspicion where an officer's estimate was supported by pacing. Finding an officer's visual estimate of speed and corroboration with the officer's observation that his car shook when the car passed. Defendant passed his brake to mount a reasonable suspicion. Finding a reasonable suspicion where officer's visual speed was supported by additional observations, that is, the vehicle's relative speed and roaring engine, and such observations were corroborated by the video camera. Another case, finding reasonable suspicion where officer's physical speed estimate was supported by separate radio dispatch indicating a reckless driving. Such additional indicia of reliability need not be great extractions of time and mathematical skill an officer may not have, which this officer clearly does not. But they do require some factual circumstance that supports a reasonable belief that a traffic violation has occurred. In the absence of sufficient indicia of reliability, an officer's visual approximation that a vehicle is traveling in slight excess of the legal speed limit is a guess. It's merely conclusory and lacks the necessary factual foundation to provide the officer reasonable trustworthiness to initiate a traffic stop. So, so can an officer, based on the visual, pull a guy over for going, 20 and a 20, going 20 and a 15, or 25 and 20? Yeah, maybe, right? But like, what is your basis for that, right? What is your indicia of reliability? And it's like, oh, I just am familiar with how fast cars go because I observe cars. We don't think that a person can slice it that enough based on that sort of generalized experience. You can sort of tell when car go real fast, but you can't tell these slight differences. There's not enough in it, without more, unless you can, point to some special experience you have, maybe that you have some specialized knowledge, that about how cars sound or something. I don't know. But unless you can point to something, right, then the mere visual by itself is not going to do the trick. Here, the deputy opined based on visual observation alone. The vehicle is traveling 70 and a 70. He did not corroborate his opinion with radar, pacing, or otherwise. So this is the problem, right? It's too thin and it's uncorroborated by anything. There is no corroboration of any kind. And that could have been potentially a lot of things. It could have certainly been radar or pacing, but it could have been other things, but there wasn't. Furthermore, the opinion was not supported by additional indicia of reliability. Therefore, standing alone, the visual estimate made by a speed differential of only 5 at a high rate of speed, because the difference between 70 and 75, if the speed limit is 5, maybe you can tell a difference of 5 miles an hour because, the difference between 5 and 10 is 100%. So maybe the reasonably prudent officer can tell the difference between 5 and 10. So a 5 mile an hour gap is not all 5 mile an hour gaps are not created equal. If the speed limit's 5, maybe you can based on your normal observation tell if a car is going 10. And the speed limit is 70, we're not so convinced you can tell the difference between 70 and 75 because there's not a lot in it. So there is not sufficient reliability to warrant a prudent person to believe they committed a speeding violation. We agree the accuracy of the estimate cannot easily, readily, and accurately discriminate between such variance in speed. Unlike a different case where the court noted there's no affirmative reason to think the trooper's estimate should be discredited, here there's a myriad of reasons to discredit and no reason in particular to credit. So basically, this bottom line boils down into the trial court screwed up by trusting this witness. So this witness was so unreliable that the trial court did it bad. So, yeah. And then there's a dissenting colleague, so they note as well. So this is 2-1. We address separately our dissenting colleague's primary contention. The record supports the expertise in visual estimates of vehicle speeds with an average of 3.5 miles an hour error. On the basis of the contention, the dissent believes the government can easily establish the deputy had probable cause to stop the vehicle for traveling 70 to 75 and a 70. Thus, in the view of the dissent, the constitutional right to be free from excessive seizure is overcome by purported expertise, which in turn depends on the road test that he satisfied as part of the radar certification. We say the deputy has no such expertise, and there's no indication in the record. The road test was designed or intended as an evaluation of the ability to estimate vehicle speeds in connection other than in conjunction with radar. Indeed, one thing we know about the road test is the deputy was required to estimate the speeds of 12 separate vehicles and then corroborate his visual calculations with the use of radar. Thus, to the extent the road test prepared deputy to visually estimate vehicle speed, it only did so in the extent corroborated by radar. Well, I'm not really sure that's a fair characterization, to be honest. So I think the dissent might have a fair point here, right? That's not really a fair characterization. It's like, yes, he did the estimate blind, and then he was confirmed as correct. So maybe that's enough. Maybe the dissent has a point, but the majority doesn't see it that way. The record also reflects the deputy may have passed the road test, but nonetheless been off by 12 miles an hour on any vehicle and 42 miles an hour on all 12. Consecutively, it's entirely possible that the visual estimates were off by 6 miles an hour on 7 vehicles and perfect on the other 5, which seems a little bit implausible, to be honest, but okay. And such, although the average or mean error would only be 3.5, the median and mode would have been 6. Given we're faced here with a mere 5 mile an hour differential, those hypothetical results as equally possible as those presented by dissent would seem to call into question the dissent's probable cause analysis. I feel like they're being a little unfair to the dissent here, to be honest, but that's why different judges look at things differently. It's like, this guy's producing an estimate blind, and then the radar tells him he's right, and on average he can only be off by 3.5 miles an hour. So, okay. The record further shows the deputy made his visual speed estimates not in a test environment where a situation has occurred, but instead on the street with actual drivers, which to me sort of even validates it more. Like if it had been in a test environment with known conditions, that might have made it more unreliable. The fact that you're doing it based on real world conditions seems more reliable in this context, to be honest. Presumably, although, again, this is unknown, the vehicle speeds of these actual drivers were impacted by a speed limit in the area tested, as well as the presence of police officers conducting the radar test. And the extent to which the deputy would use the results of the speed test to overcome the constitutional rights to be free from unreasonable seizure, prudence dictates the consideration of these and other questions relevant to the test design. The dissent overlooks these and other shortcomings and would instead find probable cause on the basis the deputies demonstrate an uncontradicted ability to visually estimate speeds with an average margin of error of 3.5. Indeed, under this line of reasoning, our colleague in dissent would apparently permit traffic stops on the basis of an officer's uncorroborated and unsupported visual estimate the vehicle is traveling 71 in a 70. And then they cite a case in which a court noted with approval an officer's testimony that is accurate, that his estimates were accurate to within 1 to 2. Following dissent's approval to his approach to its logical conclusion, we see no limits upon the officers, such as the deputy's powers and speed of estimation. Nevertheless, defies all reason to believe the deputy, particularly in light of his difficulty with distances, they really are not big fans of this, would be accurately estimating with his vision alone, with the same 3.5 mile an hour margin of error, speed of a car traveling 10 miles, 25, 50, 75, 100, 150, or presumably a plane traveling at 700. That is not fair. That is not fair. The majority is having some fun, but they're not being fair, right? That is just not a fair example. The deputy isn't trained on speed of planes. Why would he be? What are you talking about? That's just not nice. A short example from our national pastime seems particularly appropriate here. 1 year ago, the fastest pitch in the annals of baseball history was recorded, 106. While the pitch itself was remarkable in its own right, a sports reporter noted that perhaps an even more interesting phenomena associated with the actual measurement of the pitch, as 3 nuggets of information started to parade themselves as fact. Specifically, the radar connected to the scoreboard shows the speed as 106. The national broadcast radar reflected it was 105, while the radar system used by Major League Baseball, which utilizes 3 cameras on a single pitch to calculate each pitch's speed more than 50 times, pegged the pitch at only 102.4. In light of these 3 seemingly unimpeachable, entirely reliable sources, the writer is left with the inevitable question, how can one pitch have 3 different velocity? The writer went on to surmise that unless one of Champion's fastballs voyaged through the matrix, another in the source code, and a third in reality, it leaves us with a question more appropriate for philosophy class than a baseball discussion. What the hell are they talking about right now? I think we went off a little bit on the deep end, to be honest. But okay. Indeed, in the world of baseball, there's even more absolutes than facts presented in this case. For example, the distance between the pitcher's mound and home plate is fixed at 60 feet 6 inches. Likewise, the clip of the fastball has now been viewed more than 500,000 times online. Even so, and presumably despite efforts by so-called experts like Deputy Appellate and visual speed estimation, the controversy remains. Damn. The majority is really pissed. You know, the majority is really pissed. They're like, hey, why didn't Major League Baseball just call Deputy Elliott here? He'll answer the question. He knows all. Shit. Dude, they're really not having this. Majority is not having a good time, man. Here, the dissent's contention that deputies' estimates may be unreliable, uncooperated, unsupported, and yet still comport with reasonableness is not and cannot be the law. We hold that objective unreliability of deputy elements' uncorroborated, unsupported visual estimate is categorically irreconcilable with the requirement for reasonably trustworthy information, serve as the foundation of probable cause. The visual estimate that the vehicle was traveling 75 was the sole basis of probable cause to initiate the traffic stop. As such, the seizure was unreasonable and the evidence gathered must be suppressed. Notwithstanding the dissent's protestations, the sky will not fall as a result of this decision. According to the dissent, it's ironic that while a layperson can estimate the speed of a vehicle based upon his or her personal observations, an experienced and trained officer no longer can. But the irony, if any, of dissent's comparison is lost when one recognizes that laypersons do not use their estimates to stop vehicles on public highways. Because police officers do stop vehicles, their estimates must satisfy the Fourth Amendment's probability cause requirement. I don't know about that one either, majority. I mean, because I can testify in court about this. You know, if there was some accident, be like, yes, they were going 75 and a 70 based on my observations, but this guy can't because Fourth Amendment. I don't know, man. Next, the dissent contends the majority completely invalidates the road test North Carolina has employed. Setting aside that it's wholly unclear why such a policy consideration would have any relevance to the Fourth Amendment analysis. So, yes, maybe we did invalidate the road test. Also, we don't care. Today's majority opinion makes no such holding that invalidates the test for its intended purpose. The dissent further contends that today's majority opinion creates a heightened evidentiary burden for traffic stops based solely on the officer's estimate. However, the requirement that reasonably trustworthy information must serve as the foundation for probable cause dates to 1964. Indeed, the Fourth Amendment specifically protects persons against unreasonable search and seizures. We see anything heightened in the reporting requirement. Damn, the majority is not happy with the dissent or the officer. Damn, throwing a little shade at each other on this one, you know? For the foregoing reasons, we hold the deputy erred, and then there's a dissenting opinion. Let's read a little bit of this dissent so we can feel the spice flow. From the chief judge in dissent, today we establish as police officer cannot legally stop a speeding vehicle based only upon visual estimates unless the vehicle is traveling in significant excess of the speed limit, or the officer has time and practical ability to confirm his belief the vehicle is speeding through radar, pacing, or some other corroborating evidence. No longer will an officer's professional judgment alone be adequate. And the prohibition applies regardless of the extent of the officer's training experience or certified ability to accurately estimate vehicle speeds within a very narrow range of error. Ironically, while a layperson can estimate the speed, an experienced and trained officer no longer can. Deputy Elliott has more than 8 years of experience in the daily enforcement of North Carolina traffic laws and has 3 times demonstrated through North Carolina's radar certification process an ability to accurately estimate the speed of moving vehicles with an average of 3.5 miles an hour margin of error. These facts are uncontradicted. And the majority holds that Deputy Elliott's visual estimate that the vehicle is traveling 5 miles over the speed limit is inherently unreliable and without corroborating evidence, insufficient as a matter of law, not to sustain a conviction, but rather provide probable cause to stop the vehicle. In doing so, the majority effectively holds that North Carolina certification test to demonstrate an officer's ability to estimate the speed of vehicles, like similar programs employed by a number of states across our country, is invalid as a matter of law. Even though a motorist is speeding, knows he's speeding, and may well admit he's speeding if stopped, and also working alone and without a radar, can even pull the car over for a warning, as long as the driver is reasonably believed to only be breaking the law slightly as opposed to significantly, a distinction that circus never made. Woof. The judges are not happy with each other. The judges are not happy with each other, man. Let's see what else we have in terms of shade. At the outset, I find the threshold inquiry and the basis for the significant slight distinction used to trigger for cooperative evidence requirement to be unsupported by the record and unworkable for the police. Courts routinely allow late witnesses with no training or experience to offer opinion testimony on the estimate of speed, provided they have sufficient opportunity to observe the moving vehicle. As long as they have the ability to observe as established, I found no opinion restricting the reliability of admission of the opinion based on time, distance, mathematical formula for speed. Yet, under a majority decision, a police officer's identical opinion will be deemed unreliable as a matter of law and therefore insufficient to establish probable cause to believe a violation has occurred unless the officer also estimates the speed to be significant. I feel like the dissent has a bit of a point here. You know, if I'm providing testimony as a complete civilian, I can provide estimates of speed. So why is this guy not able to do that? You know, it seems, yeah. Additionally, the majority provides no clear numerical or percentage division between slight excess and significant excess. The majority explains that slight excess is a speed difficult to discern for the naked eye. It ultimately declares that no human could accurately estimate the 5-mile-an-hour variation between 70 and 75. However, there are no studies, expert testimony, or other evidence to support this conclusion, or enlighten law enforcement officers as to what speeding violation should be considered slight because it falls within what's difficult for a naked eye to discern or otherwise, nor is there evidence to support the majority's finding that uncorroborated visual estimates of speed in the slight category must presume to be unreliable. Yeah, so it's like you're not basing your opinion off of anything, majority. So you're kind of doing the same thing you're accusing them of doing. So there's definitely some love lost on this whole thing. There's definitely some love lost on this thing. I turn now to the majority's conclusion the district court clearly erred in finding the deputy is trained to estimate speeds, and his difficulty with measurements is immaterial to his ability to estimate speeds, as they didn't depend on time or distance. As I noted earlier, these factual findings, whether clearly erroneous or not, do not serve as the basis of the majority decision. No explanation is ever given by the majority to show how rejection of the district court's factual findings ultimately hold on the case. But no explanation is probably needed to be given, as the corroboration requirement alone is all the majority needs to reverse the district court as a matter of law. Although I strive to find otherwise, the majority's holding seems clear to me. As a matter of law, a police officer could never premise probable cause solely based on his or her visual estimate of speed if the speed differential is slight as opposed to significant, no matter training, knowledge, experience, certification, or demonstrated ability to estimate speeds or recite measurements. And because the majority agrees the accuracy of human estimates of speeds cannot easily, readily, and accurately discriminate between such variations in speeds. Thus, it matters not all whether the deputy was trained to visually estimate speeds, as opposed to have developing the skill during training and certification. Nor is there any indication in this case. It could have been different if the deputy had correctly recited the length of rulers and yardsticks. So basically, the dissent is all over the majority. It's like, first of all, majority, you overturn the district court as to factual findings, which you're not really supposed to do. And second of all, the factual findings you overturned didn't actually matter anyway, because nothing he did was based on those facts. So the facts were irrelevant. So first of all, you overturned the district court's facts, and then you didn't even rely on your own preferred facts as a basis for your conclusion. Your thing was all on the basis of law anyway. So why did you reach the factual conclusion? Because it never mattered in the first place. You just disagreed as a matter of law. You just wanted to chastise the court for finding this witness credible because you personally don't, which isn't what you're supposed to do. You know? So, and you did it for nothing. The dissent has a point, guys. I'm just saying, the dissent does have a point. In sum, the difficulties with measurements, no how silly they seem, or what fodder they may have made for cross-examination or trial, are irrelevant to the rule today, which they are, because does the fact that the deputy doesn't know how many inches are in a yard or how many feet are in a yard, does it matter? Not to the majority's analysis, it doesn't. Because the majority's analysis basically boils down to you can't tell the difference between 75 and 70, which has nothing to do with whether you know how many inches are in a yard or not, or whether or not different yardsticks are different for different people. Had the majority relied upon deputies' lack of sufficient training or inability to accurately recite measurements as a basis for determining it was unreliable, my dissent would remain, but would rest on a much narrower basis. I disagree with the majority's conclusion the district court clearly erred in finding the deputy was trained to estimate speeds, and the difficulty with measurements was immaterial. Under the clear error standard, a factual finding by a district court may be reversed only if, although those evidence is supported, the reviewing court on the entire evidence is left with a definite and firm conviction a mistake has been made. When there are two permissible views of the evidence, the fact finder's choice between them is not clear error. First, the deputy's uncontradicted testimony is that he was required, as part of his preparation for certification, to work with a certified instructor who showed him how to estimate speeds. That sounds like training to me. I don't know what else it could mean. Shit. At the conclusion of the course, the deputy was also required to demonstrate to his instructor the ability to estimate speeds with an average of 3.5 miles an hour. In my view, the district court's choice of words, the deputy was trained to estimate speeds, is accurate. I guess this was, they had a bit of a row. They had a bit of a row in the Fourth Circuit. I'm definitely seeing some blood being spilled on the page. Damn. Seeing some blood spilled on the page. Secondly, deputies inexplicably became confused when questioned about the measurements of feet and yards. He may well not know the correct answers to these questions, or may have just difficulty quickly recalling or converting such measurements on the witness stand. Unlike VASCAR, however, which involves distance determination and timing mechanisms to approximate speed, there's no evidence the reliability of the officer's visual estimate of speed is or should be tied to specific minimum distance or time. Yeah, so I kind of said this, right? His ability to know this is kind of neither here nor there. There's likewise no evidence that the certification procedures for estimating speeds depend on distance and time. In my view, conditioning the materiality of the visual speed of estimate on the existence of mathematical calculation ignores the reality of traffic enforcement and unduly ties the hands of officers. Indeed, as a practical matter, it seems more likely that visual estimates would perhaps more often come into play when police officers observe a speeding vehicle while engaged in their routine patrol duties and not while positioned while they can check speeds using time and distance calculations. Oof. Calling the majority kind of eggheads, right? They're calling them like ivory tower elitists over here. The uncontradicted evidence in the case demonstrates the deputy's ability to estimate vehicle speeds was based upon experience, training, and ability to observe vehicles as a person passed them, rather than upon known distance or time. In my view, the estimate was more than sufficient to provide a foundation for opinion. For the same reasons, I'm not left with definite, firm conviction the district judge, who had the opportunity to observe him, made a mistake in finding the deputy's testimony regarding small measurements was immaterial to his ability to estimate the speeds. In my opinion, the majority's decision today strikes a blow to professional judgment of police officers, substitutes our opinion regarding the ability of officers to accurately assess the speed of vehicles for the facts presented, and severely ties the hands of trained and experienced police officers to enforce traffic laws. Whether and to what extent we might require corroborating evidence for slight speed differentials for the purpose of sustaining a conviction should remain for another day. So again, he distinguishes between like it being at trial and for the purposes of the initial stop. Right. So like because they're two different purposes. So he's distinguishing. Whether visual estimates of speed with a slight differential are sufficiently reliable was by a preponderance of the evidence in a civil context likely lies not before us today. For the purpose of probable cause, an officer need only have reasonable grounds of belief of guilt. Yeah. So in a civil case, to ultimately find liability, you need more likely than not. But that's not probable cause. Probable cause is less than that. So it's not even so it's not even the civil standard. So they're saying they screwed that up too. Additionally, the majority completely invalidates the road test North Carolina has employed for its traffic officers to demonstrate their ability to estimate speed. My colleagues give the reasons for finding the test inadequate to demonstrate officers' expertise. Although my colleagues summarily deny that they should have taken the step, they nonetheless set forth in some detail the perceived shortcomings or North Carolina test for the purpose of discrediting the demonstrated abilities in this area and rendering an opinion unreliable as a matter of law. So yeah, the dissent is not having it. The dissent's not having it. And I think maybe on balance, I think I might disagree. I might agree with more with the dissent. But anyways, it was an interesting exploration of the law. It was an interesting explanation of the law, right? Because a lot of this goes to the question of how reliable do you find the officer, which is a question of fact, right? And so, because it's a question of fact, it's like how reliable do you find this officer? And the officer has many defects, but if the trial court finds him reliable, the appellate court's not supposed to reverse that unless it's insane. And the dissent's like, well, it's not insane. There's reasons to believe it, unlike what the majority says, and you know, it's fun. It's fun. Isn't the dissent wrong? A layperson can testify to speed as they are experts. Yes, they can. It's within the bounds of a layperson's opinion. A layperson can testify as to speed. Yeah, a layperson can testify as to speed because it's within the bounds of a layperson's opinion. It doesn't require specialized knowledge. So the dissent is not wrong. All right. Well, I'm going to sign off for now. This has been fun. That will conclude for now. If you've enjoyed this, please give it a like, comment, subscribe, and we'll go from there. It was an interesting case to be sure, but basically the what the Fourth Circuit seems to be saying is that for slight differences, whatever that means, the officer is going to need to have more than just like I know how fast cars go. So pure visual estimates by themselves for very small differences, apparently not valid in the Fourth Circuit, I guess. So yeah. So okay. I'm gonna sign off for now. I've been on civil law. Until later, my friends. I hope all's well. Cheers, my friends. Any rulings on distance, turn signal distance before turning? It's in the traffic code. It's in the amount of distance you have to give before turning for signaling. It's in the traffic code. I forget exactly what it is, but it's like 100 yards or something. But you could look it up for that kind of stuff. It's in the traffic code. I've been on civil law until later, my friends. I hope all's well. Cheers, my friends, and goodbye.